The White House.
Okay, 10:09 going on 10:10 Delaware. And the first day of those public presidential impeachment hearings in the U.S. House of Representatives produces new evidence seemingly connecting the president more directly to tie U.S. arms shipments to Ukraine on a Ukrainian investigation into the Bidens. Joining us live from Washington, but she's based in Camden, New Jersey, Dr. Kathryn Kovacs, Katie Kovacs, professor of law, Rutgers University School of Law. Professor, welcome. Anything that struck you about yesterday in particular from a legal point of view?
Yeah, what struck me yesterday, I think the testimony did two significant things yesterday. First, it provided a context for why it is such a big deal that the president conditioned the provision of military aid to the Ukraine, at least in part, on an investigation of the Bidens, why the Ukraine is so important strategically for the United States. And second was what you just mentioned, that there's new evidence that there was a phone call between Ambassador Sondland and Trump that would have tied the president more directly to this condition on the provision of aid. This is a deeply profound and historic moment for the country, and I think those two things were the key takeaways from yesterday's testimony.
What about this notion of two realities, two different modes of consciousness? Because you heard what the Republicans were saying, and they kept pressing on that the Ukrainians were trying to sway the campaign in Clinton's favor.
Yeah, I find it personally so disturbing that the country has become so polarized that we have different versions of reality even. But the president provided a partial readout of this now infamous phone call. So there are some things that are not in dispute. There are some facts that we know. We know that the president held up aid to the Ukraine, which incidentally the president is legally allowed to do if he provides notice to Congress that he's doing it, which the White House did not do in this situation. One has to wonder why the White House didn't provide the requisite notice to Congress. We also know from that readout that the provision of the aid was conditioned, at least in part, on an investigation of the Bidens. We also know that the president had Rudy Giuliani conduct U.S. foreign policy, which is significant because Giuliani's duty is to the president personally. Giuliani has no fiduciary relationship with the United States. He has no obligation to act in the United States' best interests. He has a legal obligation to act in Donald Trump's personal best interests. So that alone is quite significant, I think. And those things are not in dispute. And that was not what the dispute was about yesterday. I think yesterday a lot of the debate was about what was in the president's head, what was his motivation for holding up the aid to Ukraine. The Republicans were trying to say that the president was holding up the aid to Ukraine in part because of corruption in the Ukraine, which may be true. It would be nice if the president would answer that question. But according to the partial readout of the phone call that we have, that is not actually what was in the president's head.
Yeah.
But there are two different versions of reality, and I don't know that the hearings have moved anybody's opinion on their version of reality.
Well, sure. I mean, we have reported that aides told President Trump that it was a smashing success, and then you read headlines that this was a devastating day for the president. So there you go. What about a CNN analyst, actually the chief legal analyst, Jeffrey Toobin, suggesting that it's a, quote, problem for the Dems that impeachment witnesses never met President Trump personally, ever in their careers?
Yeah, I think that's similar. I'm not impressed by that. Again, the people who have the best evidence of what actually happened are refusing to testify. The president is not allowing them to testify, which alone, incidentally, is grounds for impeachment. One of the the grounds for the Nixon impeachment was the refusal to cooperate with the impeachment inquiry in the House. So the people who have met President Trump and were directly involved, the people who have the most direct knowledge, are refusing to cooperate with the inquiry. This is now the best evidence we have. So the fact that the ambassadors involved did not meet the president personally is of absolutely no moment to me. Legally, this is exactly in line with the argument that came out yesterday that all of this testimony is hearsay, which is to say it's secondhand knowledge, which is absolutely true. It is hearsay, a lot of it, but the fact that it's hearsay is irrelevant because it's the best information that we have. People are convicted on hearsay evidence in criminal courts all the time. So just because it's hearsay doesn't mean it's not valid evidence.
Well, since you're a law professor, let me ask you this. I don't know whether it's an apples and oranges question or not, but we talked before about how it just seems reflecting our political divide, an immense divide that has only widened, I think, in the last few years. It's as though there's two reference books, two realities, two versions of truth. Well, in a regular trial, whether it be civil or criminal, would you say that prosecutors and defense proceed in much the same way, different versions of facts or at least narratives as to what the reality was? And so in that sense, it's similar? Or no, there's actually more cohesion, more common grounding in that kind of proceeding than what we've had here in this political proceeding?
I think there's a lot more grounding in a trial, in a court of law. The impeachment process in U.S. law is unique. There's nothing else that's at all like it. And a lot of what goes on in an impeachment inquiry, there are no rules necessarily. The Constitution imposes no constraints on the impeachment inquiry at all. And in fact, the House doesn't have to have an impeachment inquiry. In both the Nixon and Clinton cases, the inquiry was performed ahead of time by a prosecutor. So what's unique this time is that the House has to do the inquiry itself, the investigation.
Well, like the role of Kenneth Starr during the Clinton impeachment, you're saying?
Precisely. The House was given the evidence and could proceed based on the evidence that a prosecutor had already compiled. In this situation, the Justice Department declined to investigate the Ukraine matter, and so the House was obligated to do the investigation itself. And as I said, there are no rules governing this. The House is doing what it deems best in these circumstances to uncover what happened. And again, I don't think that there's any real debate about what happened. There are debates about what was in the president's head, what was his motivation, and there is, of course, the ultimate debate about whether what the president did is impeachable.
And we'll have to leave it there, Professor. Thank you so much for your contribution.
You're quite welcome. Thanks for the call.
Nice talking to you, Dr. Kathryn Kovacs, Katie Kovacs, Professor of Law, Rutgers University School of Law, Camden, but joining us from Washington here on Delaware.